The Lok Sabha today passed the three crucial bills with a very tall claim by Amit Shah, the Home Minister, of overruling the entire criminal justice system. He said these bills will do away with the colonial mindset and will emphasize on Indianness, Indian constitution and the well-being of people. But the bill was passed in Lok Sabha with barely any opposition amid the ongoing suspension saga and no real discussion. That irony aside, let's get back to the criminal laws. Is this truly an overhaul of the criminal justice system, or is this rehashing of the existing laws? Or is this the case of changes in the right direction? In the course of next 25 minutes, we will get you domain experts to answer this beyond all the political noise. The Bharatiya Nyaya Sanhita 2023 will replace the Indian Penal Code. The Bharatiya Nagarik Suraksha Sanhita 2023 will replace Code of Criminal Procedure of 1973, and the Bharatiya Sakshya Bill 2023 will replace the Indian Evidence Act of 1872. Now let's look at what may have seemed to be the big takeaways. Terrorism has been defined now. The draconian sedition law has been replaced with a new law. Instead of criminalizing acts against the government, the new law has increased punishment by 4 years for acts that endanger the sovereignty integrity of India. The older law was defined as criminal actions against the government. In fact, terrorism now has been clearly redefined in the second draft from the draconian UAPA. The old law on gang rape had a minimum punishment of 10 years. The new has a minimum of 20 years or a life term. However, the life term has now been redefined in the second draft. It no longer means the rest of the remaining life, as was proposed in the first draft. One of the changes proposed by the Parliamentary Standing Committee. Adultery has seen change as well. Compared to the initial draft and the final bill, the new draft rejects adultery as gender neutral and reintroduces punishment of up to 2 years of enticing a married woman. Adultery was decriminalized by Supreme Court in 2018. Now, the Bharatiya Nyaya Sanhita bill has new provisions for the death penalty for raping a minor below the age of 18, sexual exploitation of a woman after hiding her identity, and punishments for mob lynching at par with murder, something that was not present in the earlier laws, and 10 years imprisonment for crimes against children, among others. We'll try and decode all of this. What does all of this really mean? And we'll get you experts on this to get to the crux of it all. But first, let's get some reactions.
पहली बार नरेंद्र मोदी जी ने ऐतिहासिक निर्णय किया है कि राजद्रोह की धारा 124 को पूर्णतया समाप्त। अब ये देश आजाद हो चुका है, लोकतांत्रिक देश है। शासन की टीका तो कोई भी कर सकता है, किसी को भी करने का अधिकार है। इसके लिए इस देश में अब किसी को जेल में नहीं जाना पड़ेगा, चाहे हमारा शासन। इस देश के खिलाफ कोई बोल नहीं सकता, इस देश के हितों को कोई नुकसान कर नहीं सकता। इस देश के झंडे, इस देश की सीमाएं, इस देश के संसाधनों के साथ अगर कोई खिलवाड़ करेगा तो निश्चित रूप से उसको जेल में जाना, और जेल में जाना चाहिए। मानिए, ये हमारी सरकार का ट्रस्ट है। इस देश की सुरक्षा किसी भी की सुरक्षा से सबसे ऊपर होनी चाहिए, सुप्रीम होनी चाहिए, सबसे पहले राष्ट्रपति। अभी जो कानून हम रिपील करने जा रहे हैं, वो कानून में मानव वध और किसी महिला के साथ अत्याचार, उसके पहले सरकारी खजाने को लूटने की सजा, रेलवे की पटरी उखाड़ने की सजा और ब्रिटिश ताज के अपमान की सजा को रखा गया था। मानव वध तो बेचारा 302 नंबर पर बैठा बैठा अपनी राह देख रहा। सुरक्षा प्रायोरिटी क्या थी? मानव वध नहीं, किसी महिला के साथ हुआ दुर्व्यवहार, अत्याचार को न्याय दिलाना नहीं था। प्रायोरिटी खजाने की रक्षा था, रेलवे की रक्षा था और ब्रिटिश ताज की सलामती रखना प्रायोरिटी थी। अब ये पूरा का पूरा बदलकर सबसे पहले महिला और बच्चों के विरुद्ध को अपराध को प्रायोरिटी दी गई है।
Now, I'm being joined right now by Siddharth Luthra, who is a senior advocate and former additional Solicitor General for India at the Supreme Court, to understand the context of these takeaways. The Home Minister has claimed, well, thank you, Mr. Luthra, for joining us at this time. The Home Minister has claimed that these bills are a complete overhaul of the criminal justice system and doing away of a colonial mindset. With your legal expertise, Mr. Luthra, how true is this?
So there are three laws. One is the procedural law, one is the penal law, the offences, and the third is the Evidence Act. Let's begin with the Evidence Act, the Sakshya bill or the Sakshya Adhiniyam. Substantially, I don't see it, barring in the area of electronic evidence, a great substantial change. In fact, the numbers are also quite similar, and the substance of the old act has really been retained. Now let's come to the procedural law, which is the new avatar of the Criminal Procedure Code. Between the last version and this version, there has been some improvement, because the last version was needed substantial amount of tweaking, and today you have that. But is it an entirely new legislation? I would say not so. Yes, they've given certain powers. They've now called executive magistrates as part of the judiciary, which is a little peculiar, because executive magistrates, though had judicial powers, they had limited judicial powers specific. But there are some more substantial, some changes brought about in terms of bringing in community service, which is very important, but that was there even earlier. But if you ask me, is there a great, and then of course trials in absentia, but if you ask me, is there a sea change, I would submit it is not so. It's really a rehashing of what they brought out the previous time, and of course with some changes, because that had certain errors and some infirmities in it. Now let's come to the third legislation, which is the substantial one, the substantial what creates offences, and that's the Penal Code. So far as the Penal Code's new avatar is concerned, they have tried to bring in some changes. So they brought in organized crime, they brought in terrorism, but I have not been able to come across the reverse burden and the new avatar of the Evidence Act. If that's not the case, then there is going to be a little bit of an issue, because you're really stepping into the domain where you already have specialized legislation. So is this, do we understand that the UAPA is going to be repealed? I would believe not. Do we understand that organized crime, which is there to which is limited to specific states, is going to go? But other than that, I don't see the kind of sea change that one would have envisaged or expected. Perhaps the executive felt that it was not necessary to revamp the legislation completely. Yes, there are name changes. Yes, possibly, the names of foreign cities have now been replaced with Indian cities. The illustrations have been tweaked. But barring limited changes which could have been brought in by way of a legislative amendment, you could have changed the name by way of a legislative amendment, and rehashing of the numbers, making it read differently, in the sense the illustrations are now all put, the general exceptions and the definitions in the old IPC are put in one place. Barring that, and reduce the number of sections, I don't see that sea change which I had anticipated.
No, but what are you really talking about? What would you have wanted to see change for the claims that are being made to really stand true? What's missing?
So I think one of the important things was, in a legislation of this nature, do we need to decriminalize conduct or do we need to criminalize conduct? I think The first thing that I would have liked to see is that a lot of petty offences should have been taken away and put in the realm of penalties and not custodial sentences. Secondly, according to me, you should have brought in open jails as a part of the system. That should have been legislatively permitted. And thirdly, the law on bail needs to be streamlined. In Satyendra Kumar until recently, 2022, Supreme Court has said that there needs to be a specific legislation. I would have also liked there to be an enhancement in the range of plea bargaining, that is to say not just sentence bargaining but offence bargaining. And lastly, I would have also liked to have guided sentences, guidelines or norms, bail guidelines and norms, because today, what are we looking at from legislation? The criminal law's role is definitely to prosecute and punish, but the criminal law's role is also to be defined in the context that we are a democracy and a republican democracy and a republic where the rule of law is paramount, and where we have articles such as Article 21 and 22. Now, once those articles 20, 21, 22 exist in our constitution, should it be a libertarian approach or should it be a prosecutorial approach? That's the question. And therefore, I was hoping that the philosophy of the constitution would find greater place within these legislations. And I will tell you one thing, illustratively.
Are you then saying the spirit of the Constitution isn't reflected enough in the changes, because that's the heart of one of the claims that are being made by the government, by the Home Minister himself?
So I would say it's nowhere near what it could have been. We had a colonial era law. If we had to do away with it, there was a lot to be done. We're a country where the citizen is the ruler, not just the ruled. Whereas in the colonial regime, there were foreign rulers and we were ruled, and that should have been reflected more definitely in this legislation. According to me, the government had opportunity to do a lot more, and over a period of time, I am hopeful that they will be guided by judicial decisions, be guided by their own study. Let's understand one thing: in every country in the world, you want to change a law, you first see how it operates. 10 years, 20 years, you do a judicial legal audit of that legislation. So I ask myself, have we done the necessary legal audits ever about the IPC in the last 20 years?
Advocate Luthra, but a lot has been said about revamping the justice system for women and children as victims and survivors of heinous crimes, and that these new soon-to-be-made laws have them all at the center of it all.
So, but they've already got laws. They've got POCSO. They've got specific legislations. They already brought in the amendment post the Nirbhaya case in the Criminal Law Amendment Bill of 2013. So those amendments, those changes had been brought in. You've increased punishments, you've brought in more sentencing. I'll give you a simple example. An accident is now punishable with 10 years imprisonment. A rash and negligent act. Please tell me the rationale of that. A person other than driving a car does a rash and negligent act, is punishable with 5 years. You're going to punish doctors for 5 years? When we know that death is likely to be caused in certain surgeries, and these areas are gray areas at times. So my point is this: however we look at these legislations, you had the opportunity to take this a lot forward. And while you must ensure that the rights of women, the rights of children are protected, by the way, we have the Juvenile Justice Act for that, and we have now, under the Juvenile Justice Act, made in 2015, we've said that you can punish young children 16 to 18 years as adults. So I ask myself, is that protecting children or is that harming children? So therefore, I would say, when we bring in legislations of such import, we must be coherent in the philosophy that we are bringing behind them. And punishment is one aspect of it. The guilty must indeed be punished. But the process must not be the punishment. Merely saying that adjournment should be limited, trial should go on day to day. The point is, do we have the infrastructure of the judges? We've had these provisions in the code for 150 years. Only Kerala ensures sessions trials are done day to day. Other states do not. Why can't we follow the Kerala model? Is it a question of infrastructure or laws?
All right. Right. Thank you very much, Advocate Luthra, for joining us with that very important perspective. Let me also quickly introduce our panelists. We have Saira Shah Halim, who's an author and activist, joining us. Nikhil Palli, lawyer, who's also a lawyer, and Khushbu Jain, who's also a lawyer. Nirmal Kaur, the former IPS officer. Thank you very much for joining us. Let's do a quick dive into what their perspectives of these laws are. First, let me just bring in Nirmal Kaur, who is a former IPS officer at this point. One of the questions that's being asked is there really any change in terms of what we will see on the ground? There's a law that has now been brought in. Claims are being made of moving away from the colonial mindset. But are we prepared for this on the ground? Will anything change on the ground?
This is a new set of laws for the new Bharat. And many changes have been envisaged. And our learned friend who was just speaking before me on the with you, he was in conversation with you, Mr. Luthra. He had many criticisms to make. But everyone knows that a lot of opportunity was given. Suggestions were invited from all stakeholders, even the normal citizens. Anybody could give any advice to the when the amendments were proposed. The proposed amendments have been in public domain for quite some time, and suggestions were invited from everyone to improve it. I'm sure he has given his suggestions and they've been duly deliberated over. And as a citizen, as an aware citizen,
right, ma'am, how do you see this impact people on the ground as law enforcers? Do you see the system change? Is it going to facilitate any change as a law enforcer?
I think definitely it is going to facilitate changes in many areas, especially those affecting women and children. See, now we have this very productivity of the nation. GDP depends on productivity of the women. Women, if they don't feel secure, they don't come out in public areas, they don't contribute to the national wealth. And now, there is no compromise in the new laws against, for people who indulge in crime against women. Gang rape, 20 years imprisonment, life imprisonment. And, if a child is less than 18 is raped, then, it can even be death penalty, capital punishment or life imprisonment. And,
right.
If you hide your identity and you trap a woman, that again has been made a very strong crime now. So I think offenses against women and children, against organized crime, name you it. Any areas which were lacking, sedition, forensics, the use of technology.
Absolutely.
All these things, they have been
Thank you, ma'am. Let me just also get the comments from my other panelists at this point. Right. Saira Shah Halim, please come in. How do you see things change with this new law on the ground?
See, this is, this bill will have far-reaching consequences because India will see a new way of how crime and punishment is seen. Now, the tragic part is that the opposition was absent from the parliament. We've seen how more than 140 parliamentarians from both the sides of the house have been suspended on disciplinary grounds. Now, whenever any bill is passed, there needs to be consensus, there needs to be deliberation, there needs to be a debate. Because an executive decision is very different from a legislative decision. So here the legislative decision is not there because this has not been discussed, this has not been opposed, and this has not been deliberated upon. Because we've seen that the fundamental objection to the first draft of the bill is not removed in the second draft. And the character of the bills remain fundamentally anti-democratic. So the bulk of changes made by the second draft of three bills are almost editorial and inconsequential. So what I'm saying is that this is not a bill that needs to be taken lightly. Here we are going to view crime and punishment And in this case, the opposition needs to be present. We need to take accountability. We need
Okay. All
legal
right.
body to even take
Okay, let me get in Nikhil Pali
look
at this
at the
point.
bill.
Nikhil, how would you look at this? Is there a law with teeth, but do you have really the enforcement bandwidth on the ground?
Well, to begin with, the first thing I'd say is, we might be supporters of this law or we might be critics. But I think one thing in which the whole country will unanimously agree is that we needed a change. They're 150-year-old laws. I think whether it's once it's notified in the Gazette after the president's nod, once it's implemented, once we see action on the ground, we might be in a better position to say whether it served its purpose as it intends to or as the government says it is or not. But at the moment, I think what was of utmost importance was we needed a change. If you just see the way the laws have been going on since 1860s, 1870s, and I personally am at the outset, I think the bona fide intention, especially of the core matters regarding crime against children, women, I think it needed a lot of attention in our country because that really brings a bad repute to our country that it's taken easily over here. And I think that is something which in the limited time that these have been out, I've seen is something which I'm really personally happy about. But we'll need to wait. The intention for as per me seems to be very bona fide, and I think it was the need of the hour.
All right, a lot of praise here from different sectors for what seems to be the focus on women and children, the crimes against them, and how this is going to be dealt with. Khushbu Jain, who's also a lawyer, one of the allegations which are coming against the move of these three new laws is that it's rehashing a lot of existing legislations.
See, the idea was not to completely let go of the existing or, bring in something new to put a poll. You have to understand that things which made sense are still part of it, but there have been changes looking into the current scenario, this being really 150-year-old, more than 150-year-old law. And one has to also see that there has been a lot of changes that have happened either via judgments from the Supreme Court or either via the way things have been transformed after the Nirbhaya case, the way changes were happening. So this has been a little incorporating those things. If I have to just point out few, you have to understand that, increasing the threshold for victim to be, in women case, threshold of the victim of a rape to be increased from, in case of gang rape, to be increased from 16 to 18 years is one welcome move that one has to look into. The other part which is there, like for example, sedition, which was being utilized, it was an archaic law which was being misused so much. Now that has been removed as an offense in the new act, and courts were also very prominent in putting that in place. So sedition has been completely removed. Instead, it talks about penalizing in aspects of, in the event of armed rebellion or, encouraging the feeling of separatist activity. So things like that. So they have made it a little more clear that what exactly do you mean by sedition? Because sedition was one word which was been misused due to its vagueness. So bringing in more clarity as to what do you understand by that and in what scenarios there would be.
I think the point of getting our panelists here is to get the different perspectives. One thing that comes out from all four of them, what they've been talking is that it is a promising beginning towards one side. How this is really going to be enforced, how things are going to change is something that we all will have to wait and watch. That's all we have time for right now. Thank you very much, ladies and gentlemen, for joining us on our panel, and thank you for watching us. That's a wrap for today.